So good afternoon, everyone. Thank you for being here today. Thank you for your patience. My name is Sheila Lamb, and I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia Small Business Development Center is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 26 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one advising services are available at no charge. Today's webinar, Patent Basics, is presented by the Virginia SBDC Network in collaboration with the U.S. Patent and Trademark Office. Be sure to check out the next webinar in this series, Trademark Basics, on March 18th, and I will drop that link into the chat momentarily. We are recording today's presentation, and it will be posted on our website, virginiasbdc.org. Due to the large number of participants, everyone's microphone is muted and the chat feature is turned off. But if you have questions during the presentation, you can type those into the Q&A box, and we will take care of those at the end of the session. We've also enabled the live transcript function, which you can show or hide via your own meeting controls. And now it is my pleasure to introduce our presenter for today's session. And Edgar, I hope I say this right, Edgar Guerrero Erazo?
Close. That's good enough.
I apologize.
No worries.
Primary patent examiner and technical trainer, the USPTO's Technology Center 2600. In this work, he examines patent applications drawn to artificial intelligence applications, including computational linguistics, speech processing, and audio compression. In addition to examining and patent examiner training duties, Edgar is currently supporting and presenting webinars in English and Spanish for the USPTO's Eastern Regional Outreach Office. Edgar is a recipient, I can't speak today, of a U.S. Department of Commerce Bronze Medal Award in fiscal year 2014 and Exceptional Career Award in fiscal year 2019. He has both a Bachelor and Master of Science degrees in electrical engineering from George Mason University and an MBA degree from the Virginia Polytechnic Institute and State University. Please join me in welcoming Edgar. Thank you, Edgar, for being here today.
Absolutely. Thank you so much. And glad to be here. And my apologies, just a few minutes here and there. I'm just trying to troubleshoot on my end. And I just recovering myself with from a really bad cold. So please, I apologize my voice. And if I sound a little bit funny, please, my deepest apologies on that too. So just wanted to double check if you're able to see on your end. I just don't want you to see the presenter displayed, but rather the other side.
Yeah, we're actually seeing both the notes and the main screen.
Let me just swap that really quick. And
there we go.
Okay, excellent.
It's all good. Okay, I'm going to hide myself and let you take over.
Thank you so much.
Thanks, Edgar.
Absolutely. All right. So okay, so welcome. So thank you once again for the warm introduction. It's our pleasure to be here with you guys. Just we're going to go ahead and share a few of the resources on behalf of the Northeast Regional Outreach Office from the USPTO, the United States Patent and Trademark Office. Once again, my name is Edgar Guerrero Erazo, primary patent examiner, and also collaborate as a special advisor for the outreach team. Today, we're going to be discussing with the topic of patent basics. And for those of you who haven't been introduced to patents, we'll give a brief intro to that. But before we start, it's important to have this disclaimer here. It's essentially that the content is for informational purposes only, and it is not legal advice. Please make sure you consult with the appropriate sources for legal authority and guidance on these matters. All right. So some of the objectives on today's discussion will be directed towards the contents of a patent application disclosure, as well as explaining a little bit of the enablement requirement, and also how the legal boundaries of a patent, in this case the claims, can be drafted and can also be modified based only on the disclosed invention, in this case at the time of filing. Also, importantly, is that when you draft when you work on your patent application, to make sure you capture the invention using clear and consistent language throughout the disclosure. So just as in a nutshell, when it comes to the contents of a patent application, we need to recognize several elements in that specific area. The detailed description, in this case, the drawings, the abstract, and the claims. Just get a little bit of. All right, so when it comes to utility applications, utility patent applications, we have two kinds, and one of them is the provisional patent application and a non-provisional. What are the main differences between these two? And you should be able to see here an example of a patent here, a US patent. And this is for a snowman accessory kit is what it's called. But I think it's really interesting to see here that the main differences between a provisional and a non-provisional. And let me just go back a little bit. So what is a provisional patent application? A provisional patent application is an application that is only used for utility patent applications, which is not examined, which is it gives you the option for a fast and opportunity, let's say, to file your invention without any restrictions in terms of you don't have to draft a claim, you don't have to have you don't have to be in compliance with the specific requirements of a non-provisional, and there's a 1 year time limit, and within this time year limit, one year time limit, you will have the opportunity to come up and draft and get all the details that you will need for your non-provisional. Now, when we're talking about a non-provisional application, this is really important because this needs to comply with the requirements of that patent application, essentially, and it is examined. It requires claims. It requires a written description. And when we're talking about the written description, we need to meet all those requirements. Of course, eventually it'll be published 18 months from the earliest filing date, unless there's a non-publication at filing. And most importantly, it can become a patent in the case of the non-provisional. Now, something I didn't mention in describing the provisional patent application is that once you file your provisional, you have the opportunity to immediately put that patent pending on your product. So provisional patent application is a really good strategy when it comes to get your invention right into the office and immediately not worry about if you were to, let's say, to give any presentation. Of course, you have to take all the different measures, and of course talk to your legal advice at that point whether how you should be proceeding. But the provisional, definitely it's a great strategy to start with. Now let's discuss a little bit in terms of the title of the invention. So in an invention, it's really important to offer a title that is short, that is specific, and that offers a description of the invention. So if that is the case, let's think about how the title should be as a quick description as possible for your invention. Please make sure you avoid general language such as system and method for, or also there's a reason for that, because if you were to search, let's say, for a reference that could be applicable prior art to your application, there could be a situation that you're going to be facing the same issue. Oh, this is just, it says a system and then the method for processing, but it doesn't clearly delineates the specifics in terms of the description of the invention. So we always suggest to applicants to think about the generic versus the specific language when it comes to the title. Now, the title is also important because it should allow the reader to immediately ascertain what your invention is about, and that's really let me see if I can move my, well, that's fine, your invention essentially. Now, when it comes to your to the specification, this is the other area it's really important in terms of the components of an application. you need to think about how the written description is provided with respect to the invention. In other words, how to make and use the invention. Please be clear, be full and concise in terms of offering exact terms to allow any person of ordinary skill in the art, in this case, in the technology of the invention, to make and use the invention. And at least it should contain one specific embodiment. Please make sure you conclude with at least one claim and this should start on a new page. Of course, we have a lot of requirements in terms of a page format and so, but there's a reason for that. The reason that the office requires that applicant complies with when it comes to page format, it's because there should be only uniformity in all applications. And when it comes to the specification, please make sure that you include the abstract and the claims in this case. These should have lines that are 1.5 or double spaced in a single column of text. There are other requirements in terms of it should be written only on one side of in portrait orientation, the 8.5 by 11 inches in terms of the margins, 3/4 of an inch in this case, except for the left side margin of at least 1 inch, and different other requirements in terms of consecutively numbering the application pages and also having a font that should be Arial Times Roman or Courier, in this case of a font size of 12. More on the specification sections. Of course, when we're talking about the title of the invention, we already mentioned that they should be short and specific. And also some of those most common application sections, such as the background, a brief summary of the invention, a brief description of the drawings. And also, when it comes to the brief description, it's really important that it should be listing all figures by numbers, and essentially also offering a brief statement of what the figure depicts in this case. A detailed description of the invention, and also something that we should also highlight is that when it comes to the background, you should clearly state the art before your invention, because this offers some sort of a previous picture of what your invention is about. The claims, of course, should be on a separate page, the separate page essentially, and the abstract should be less than 150 words. It should be in the one paragraph, and it should also be on a separate page, separate sheet. These other lesser used sections, such as, for example, the cross-reference, which is a section that connects related applications, should also be included if you're filing, in this case, if your application happens to be a continuation or a divisional, or whether you're claiming a priority to a provisional application. Of course, statements regarding federal sponsored research, names of parties, incorporation of reference materials submitted via a text file of compact disk, and also a statement regarding prior disclosure by the inventor or joint inventor in addition of a sequence listing. Now, continue with the background of the invention. So this is an area where you will be describing the field of the invention, and make sure that you allow yourself to describe it at a high level in all those areas that are pertinent to your invention. When we're talking about the description of related art, we should be describing what you know in this case or has been done before. Also describing the problems that lead you to come up with your invention, and of course, what prior art you know about your invention in this case. So in terms of the brief summary of the invention, and I think in this presentation, we're just trying to describe each and any of all those components of the application. So if you find a little bit of those of that information a bit repetitive, a bit specific, and just bear with me, because it's really important to get this straight, to get this clear, because if there's something that is not filed according to the instructions, there could be some issues in terms of at that stage of pre-examination. And the most importantly, you should be very optimistic and also should be highly concentrated on getting an effective filing date as soon as possible. And you will not get an effective filing date unless everything is in order, everything is in compliance with the requirements. So that's the main reason that we describe in this presentation. What are the components, the specifics in terms of format, and also the just going through each and every of those sections of the invention of the application essentially. So also, going back to the brief summary of the invention, this should be a description at a high level, offering what your invention is. If you consider, should be consider yourself to describe problems that you're solving using your invention, what makes your invention special and or different, and also what your invention does in a nutshell. The drawings, this is an opportunity to offer those illustrations to connect the components of your invention. Yes, of course, when we describe it in text, we're just trying to offer as much detail as possible, but the drawings offer such a tremendous connection between what is in text and what are the elements or components of your patent application, and also how can you definitely see an illustration of that. And the drawings, the figures offer do a tremendous job in that respect, because this is a part of the application papers. And in this section, you need to provide, this needs to be provided essentially before the application is considered complete and released from the initial process. And that this is the area where I was mentioning about pre-examination. So for the drawings, essentially, this must include a brief statement of what each figure depicts. In this case, whether there is a front view of the invention and also an expanded view of the elements prior to assembly. Continuing with the drawings, as we mentioned, part of the disclosure, it is required if it is necessary to understand the invention. And each drawing is necessary in order to understand the invention so that the invention cannot be introduced after the filing date. So this is really important because once you get a filing date and you decide to, oh, I should have included drawings or a figure to better describe or illustrate this part of my embodiment or any of my claims, at that point, your application has been already complete in terms of the requirements. If you decided not to provide drawings, then at that point, you will not be able to introduce any drawings because this could be considered a new matter. Is that what we called? Also, drawings must show every feature of the invention claimed, must contain as many views as necessary to show the invention. There are two acceptable standards for drawings, and this can be, you can find reference to this on 37 CFR, one of the rules, 184. It should be either black and white drawings, which are normally required for utility and design applications, and color drawings, which are permitted in design applications as well. Going much more in detail in terms of the drawing requirements, as we mentioned, the black and white drawings using reference characters in the specification and drawings. In this case, numerals preferred. The numerals are definitely preferred. So, for example, if each figure must be labeled as, for example, FIG.1 or FIG.1, that should be the recommended labeling. Also, avoid using descriptive words in the figures. Now, the abstract. This is really important because sometimes in applications we get to see that the complete set of claims are described in the abstract, or it's something that is huge, or it's more than 150 words. So the abstract should be your opportunity to offer that sort of a sales pitch. So this is my invention. This is what my invention does in 150 words or less, and being able to convey what the invention is in the abstract. That's really important. Of course, when it comes to the format, as we mentioned, a narrative form, a single paragraph points out. We need to point out what is new in the technology, and make sure you don't repeat what is in the claims, because this is an opportunity to capture that examiner when he or she is reading your application, and make sure that since the abstract is part of the application, you make the best job that you can when you draft that. Also, it must be written to enable the public to quickly determine what is the nature of the technical disclosure of the invention. For more reference or for more details, you can also consult the MPEP. This is the Manual of Patent Examination and Procedures on section 608.01b. Just get a little bit of water here. Now, talking about the detailed description of the invention. So this is really, really, really important. I wouldn't say that if it is not the most important part, because the detailed description offers this roadmap, this the description, the complete description of the know-hows, essentially, right? Of how your invention is enabled, how your invention is disclosed. And it's an opportunity to explain essentially how the invention and the process of making and using it's provided full, clear, concise, and using the exact terms. Please make sure you focus on explaining the structures, the processes, and also the compositions of the invention. And as I said, a roadmap to go back between, so then there should be a clear navigation, let's put it this way, between the detailed description, the claims, and the figures, right? In this case, because you should be able to navigate or to navigate from any of these three elements. And of course, the abstract, everything should be harmonized. But when you're referring to the figures, you should also be able to find reference in the text, in the description, should be also be finding, being able to find reference in the detailed description, in the figures and in the claims, essentially. And for more reference, MPP section 608.01G. Let me see what we have here. So continuing with the detailed description of the invention, as we mentioned, it should be clear support or antecedent basis for all terms. This is really important because if for some reason the examiner happens to find that any word in your claims seems to be disconnected or there's no support to the specification, to the description, there could be issues in terms of disclosure when we're talking about USC 112. And that's one of the laws that we examine when it comes to the written description component of your application. And also, you need to make sure that all terms used in the claims will have, as we mentioned, support on an antecedent basis or disconnection, so that the meaning of the the claims may be ascertainable by reference to the description. Of course, it's important and helpful to draft your claims first. This is something that it's always recommended. So when you draft your claims, so this is a great opportunity so you can decide on the terminology that you will be using, essentially. And also at the same time, you make sure that the terminology that you decide to use is consistent throughout the specification. You can also figure out, in other words, which terms will need to be defined or explained in more detail in the specification. And also, the claims can be a checklist to make sure that the detailed description offers clear support for the claims. Now, I think we have spoken a lot in terms of excuse me, of the requirements of the application, the summary, the description, the figures, and we haven't gone into the claims yet. But so far, it's important to recognize those green points, right? Those specific areas of recommendation. And let's offer a summary for that. So first of all, make sure you describe your invention clearly to allow any personal skill in the art to make and use the invention without undue experimentation. Second, when you refer to drawings, please make sure that each reference number or numeral is used for only one part as depicted in the drawings, and that each reference numeral it's shown in drawings, which is also mentioned in the specification. We also discussed briefly that uh, at least one specific embodiment should be included, including essentially in this case the best one known to you at the time of filing. Also, a brief description of the drawings. This is a section that includes how each figure is referenced by its full label, and then we explain those suggested labeling. Also, the proper antecedent basis for all terms in the claims, and also make sure you focus on the technical features of the invention. The red points or the things that we should not be using in this case. Please do not use trademarks in the title or in the description or to describe the structure. Also, and also do not use a mark or a logo brand so you intend to register for commercial product later. The background of the invention section does not need to state how the inventor conceived the invention. Sometimes we get to see some of, when the aha moment came in, whether I was, talking to a friend or doing certain activity, and then you don't need to describe that. Also, avoid making claims for possible future success. This is really, really important. Also, do not include a detailed discussion of the figures or refer to the reference characters in the brief description of the drawing section. So we clearly highlighted that. Of course, also do not forget to proofread your specification to look essentially professional, presentable, and so that you can catch up those grammatical errors. All right. Out of this presentation, I think this is the most important part. And why is that? Because the claims are the legal boundaries of your invention. These are the legal limits. In the same way as a physical property has that many square footage or that many limits in terms of what's surrounding that property, that physical property, the claims are these metes and bounds, these legal limits, legal boundaries of your invention. That's why they're really important. So if it is in the claim, it must also and specifically be in the specification in this case. So make sure that when you define the invention and what aspects are legally enforceable, this should also be in the claims. The claims must conform to the invention as set forth in the remainder of the specification. Now, you may remember that we were talking about this roadmap, these connections between the specification, the figures, the drawings, and the claims. Also, when it comes to terms and phrases used in the claims, please make sure that you must find clear support. And once again, antecedent basis in the description so that the meaning of the terms in the claims are clearly understood by reference to the description. Now, what are the form of the claims? You should start claims on a separate sheet with the heading claim listing, essentially. Claims should be, claim sentences essentially should be 1.5 or double spaced. And in this case, each claim is an opportunity, it's a single sentence which begins with a capital letter and ends with a period. There are these three independent claims, 20 claims total before excess fees are due. And also, when you're numbering, you should be numbering those claims consecutively in ascending order. Original numbering preserved throughout the prosecution. This is really, really important. All right. So, excuse me, let me just get it away. All right. So, when we're talking about U.S. patent law requirements, so it's important that recognize that a non-provisional patent application must have at least one claim, particularly pointing out and distinctly defining the invention. And just let's just be very cautious here. A non-provisional patent application. All right. So when we're talking about a provisional patent application, you don't have that. So, but it's really important when it comes to U.S. patent law requirements that a non-provisional should have at least one claim, particularly pointing out and distinctly defining the invention. A claim may be written in an independent or dependent form. Of course, dependent claim. A dependent claim definitely refers to a claim previously set forth and then further limiting the claim invention. And when it comes to a claim independent form, this needs to this one needs to incorporate by reference all the limitations of the claim to which it refers. Now, let's discuss a little bit of the scope of the claims, essentially. And when we're talking about an invention, um, we would highly recommend to visualize this pyramid of value, essentially. You wouldn't want your invention to be too specific, because it could be that if it is too specific, it may not have the value that you're looking for. Whereas if it is too general, then it could maybe the other extreme, which is it's going to be not patentable at the end. So think about this middle point where your invention should be as specific as you need to claim it, and also as general as you need to have it in terms of your strategy. So once again, please make sure that your invention is delineated by the claim. So how should an invention be delineated by the claims? It's just enough subject matter in the mention so that it is you're in the kind of in this middle point of the according to this pyramid of value. All right. So okay, so let's discuss a little bit of claims in this. So when a claim is too broad, so let's see this example. So we have a vehicle comprising a frame, first and second front wheel, a first and second rear wheel aligned and spaced behind the first and the second front wheel. Also a seat connected to the frame and a removable top portion made of cloth, wherein each wheel rotates and is connected to the frame. And I think the broad picture here is essentially this is a broad claim. Let's just see a vehicle and several additional features. Are we describing that sort of vehicle next to the convertible? It could be when we're making a broadest reasonable interpretation of the limitations of that claim. That's fair game to see that could definitely be reading on that type of vehicle, right? So how can we make it more specific so that we clearly describe the vehicle on the left? And this is the other extreme. If your claim is overly specific, now we're describing a motor, we're describing that the frame is yellow, that it has this plurality of hinged doors, and also that there are glass windows connected to the frame, two red lights connected to the frame, two metal bumpers connected to the frame, and that also that the removable top portion made of cloth, and where each wheel is made of rubber. So much and overly specific at that point. So what's the lesson here? The lesson here is that before you draft a claim, let's strategize about that, right? So make yourself a space to answer the following questions. What is the invention? What are the pieces and parts that make up the invention, essentially? How do we how are we able to connect those pieces and parts, and also how are we going to be able to relate one another? And do you have more than one invention? This could be not only a method, it could be an apparatus, a machine, a composition, and also making sure that you offer a clear distinction between the tangible and the methods, and how the methods offer this making, and it's a clear teaching of the making or using. Are there any multiple versions of each invention? So it's really interesting to see. And as we mentioned, let's think strategically here. So what is it that you are hoping to accomplish? Whether you're more concentrated or your strategy is just to get the broadest valid claim possible, or whether whether your target is to obtain claims with a variety of claim scope, or just not just at the time of filing, but during prosecution. So in this case, are at least some of the claims you filed likely to be patentable without amendment? So there are additional resources for that. Okay, so we should be also recognizing here in the case of if you're concerned with 35 USC section 154D of provisional rights. In this case, there's a reference here that because the Federal Circuit has interpreted that this provisional right, or some call it the pre-issuances damages the statute, as that an actual notice of the published patent application is a necessary element of infringement, even when the infringer buries its head in the sand to avoid the knowledge of the application. So it's about at the end of the day, it's about the speed versus possible quality patent claims. So the sooner your patent is granted and published, the sooner the date for you to obtain these provisional rights from the date of publication, which is an actual notice. All right. So let me just continue here. Okay. When we're talking about strategy, we also need to think about affordability. In this case, some applicants may encounter this situation, others may not, but you need to think about how much you can afford to spend on claims. Whether that is in the case of independent claims in excess of three, and then it's going to be a value for each of those cost for each of those claims. And of course, if the total number of claims excess 20, then there should be other additional fees that you need to also consider. So not just at the time of filing, but also during prosecution. So it's really, really important to keep this in mind. And of course, all the above costs are for microentity. So now, when it comes to claim drafting, we are also talking about in terms of utility application. We mentioned these three main parts. Uh, a claim essentially should have these three main parts, which are the preamble or this introduction, a transitional phrase such as comprising, which is an open statement, consisting of, which is a closed statement, and number three, the body reciting the elements of the invention. And these three parts, when it comes to claim drafting, are really, really crucial. Continue with transitional phrases in patent claims, comprising versus consisting of. Comprising, as we mentioned, this is an open statement which comprises most commonly used open-ended. A claim encompasses all of the listed elements and may also include more, right? Consisting of is more of a closed-ended statement. Claim elements in this case will be limited to as listed and no more than that. So in a nutshell, we can see that when it comes to claim drafting, those positive points, just in summary, make sure you particularly point out and distinctly claim the subject matter regarding as invention. Consider drafting your claims first, and then your specification based on the terms used in the claims. Review both description and claims to make necessary additions and corrections. Look at the claims in patents issued in your field of technology that offers a lot of support in terms of terms of art that could be used. Also, make sure that each term is properly processes proper antecedent basis. Think about what legal protection you need for your invention and tailor your claims accordingly. In this case, the negative points, please do not use claims converting two statutory classes of invention. In this case, widget and method for using the same. That's the big red dot right there, because this could be considered a hybrid claim. Hybrid claims are not patentable. Please do not use terms inconsistently between the claims and or its specifications. So if you define it in a particular, you have a certain definition and then you change your definition or the word as you go into the claims or back into the specification, that's not recommended. Do not write multi-sentence claims. Also, do not refer back to only a portion of another claim in a dependent claim. Remember, those dependent claims are under the complete and full umbrella, and in this case, scope of the independent claim. So it should have all the subject matter of that independent claim, in addition of these further limiting elements in the dependent claims. Of course, also do not replace elements from another claim within a dependent claim. All right, so some of the support and resources. We have access to free services when it comes to being able to learn and get additional information, how to prepare and file, applying for protection, and different other resources. If you have a question about your application or any patent application, we invite you to contact the Inventors Assistance Center, and they have so the phone number is 1-800-PTO-9199. And their business hours is Monday through Friday, 8:30 a.m. to 8 p.m. Eastern Time. Also, if you happen to be close to one of the Patent and Trademark Resource Centers, or PTRCs. These are programs that are assigned by USPTO nationwide. This is a network of public, state, and academic libraries designated to share, to evangelize, to disseminate the patent and trademark information, support diverse IP needs to the public. And also in a PTRC library, there are representatives that will be ready and willing to help you to provide access to resources, offer additional explanations for your application process, the fee schedule, and also training information that should be really, really useful for your for your uh, um, for your journey in terms of getting patent protection. For more information, you can access, and there should be a PTRC in your geographical location, wherever you're located. So www.uspto.gov/PTRC. We also have resources for which are pro bono program. The pro bono program is a fantastic program that offers the ability to connect a legal practitioner with an applicant, with an inventor. Of course, this matching occurs based on certain guidelines that the federal government provides. So, but this resource is there. Once again, it's a nationwide network of independently operated programs that match a volunteer patent professional with a financial under-resourced inventors and or small business. All right. For more information, there's an email right there. And also we also have the law school clinics, also part of the work in tandem with the patent pro bono programs. All right, I think that's pretty much what I had for today. If you have a question, please, we invite you to kindly reach out to us. Here's my director's email, my email. Um, Anything or any question as basic or as advanced that you have in your patent filing journey, please make sure to reach out to us. All right. I don't know if we have any further questions at this point. I'm gonna go ahead and stop sharing.
Yeah, thank you, Edgar. That was very, very, very informational. We have a couple questions that have dropped in. And if you're able to answer them live, I'm going to go ahead and read them out and let you, if you're able to answer live, if you don't mind, that would be great. And some of this you probably covered later on, but I always like to read the questions just so everyone, can benefit from it. So one of the questions was, if I already have a patent and I improve on it, do I need to update my patent or apply for another one?
So you don't need so here's the situation. I think we were sharing some of those slides. If you have an improvement of your invention, you could, and then please, we're not allowed to offer any legal advice, but we do offer IP education. There are certain types of applications, such as, for example, a continuation or a divisional, and this is the opportunity, or continuation in part. This is the opportunity for you to file a continuation application in which you will be describing the improvements of your previous invention. Of course, you will be extracting reference and in terms of the content in your divisional, in your continuation, or in your continuation in part. But that should be the process to follow.
Okay. Furthermore, if I invent a few more products in association with that patent, do I need to apply for a patent on each of those products?
So when we're talking about products, most likely this could be embodiments of the original application, or this could be, once again, a connection to improvements. That's a decision that you'll have to make at that point. If you're thinking that you have a related invention, most likely this could also be a continuation, a divisional. But if you're thinking that this is completely something totally different, a product that may not be necessarily connected to your invention, this could be another invention essentially.
So can you get both a design and utility patent for the same invention?
So there's a principle. One patent, one invention, one patent, right? Of course, there are strategies in how you can protect your through the intellectual property rights, right? So that really comes to the point, what's going to be your strategy? And we highly, highly recommend that you talk to your legal advice, because there could be when we're talking about a design patent, we're talking about the ornamental appearance of that product, and that is not by definition utility. So you will not be able to protect utility with that design patent. And the same, the converse is also true. So it's really important that if you consider your invention as a whole, take the appropriate steps, take the proper counseling to see how this could be protected, because it may not also necessarily be only design patents and utility patents. Could be copyrights in there. There could be a trademark also, and there could be trade secrets. So please consult with your legal advice as soon as possible.
How can I evaluate whether my invention is too close to what is already approved?
Okay, so if how can you make an evaluation? So if you have already you already filed your application with the office. As an applicant, as an inventor, you have the duty to disclose, right? So make sure that you did your due diligence in terms of searching applicable references. So we have several resources. We have our searching capabilities, our searching resources. We have also also have many other open domain tools. For example, and it really depends how your invention, how the complexity of your invention. There could be scholarly articles already published. There could be, magazines, products, things like that. So it's in you to offer that duty to disclose. So it's really, really important that you outsource everything as possible in terms of what could be applicable to your invention. That's part of and submit that in our information disclosure statement, which call it IDS. So make sure you disclose everything, so the examiner will have the tools and the resources that you did that you essentially did your job in terms of submitting that, what could be applicable, what could be out there.
Let's see. So this one was referencing, it says on specification, what is an example of embodiment?
All right. So let's say, for instance, you have that your invention, in this hypothetical example, you have all right. So let's say you have a processor, you have memory, and you have a another graphical processor, right? So you're describing your invention, and just this hypothetical example that I'm describing a CPU in which I'll have my processor, regular processor, and memory. That could be an example of one embodiment. Another embodiment could be that you have a graphical processing unit in which you'll be using this additional graphics capability with a CPU and with memory. That could be, an example of a second embodiment. Have a different way how to operate with additional elements. And please, that's just something totally hypothetical. Of course, when you are the creator, you are the composer, the inventor of your invention in this case. So you will definitely see that if you modified certain parameters, oh, this could work this other way. Perhaps that could be described as a second embodiment or third embodiment.
Let's see. Another question was, can you restate the difference between provisional and non-provisional invention?
All right. So the main difference is that a provisional patent application is not published. This is really, really important. A provisional patent application is not published. It has many differences. I can tell you that the advantages of filing a provisional patent application, it gets your feet in the door of the office. It allows you to get an effective filing date with a small amount of resources and with a high impact down the road in prosecution. Whereas if you were to start with a non-provisional patent application, you're going to have to meet and comply with all those requirements to have a fully and complete non-provisional patent application. The price is higher. You have to have a claim, Whereas in the provisional, you don't need a claim. You could have, let's say, if you have your research, you have a research paper, and you would like to file that as a provisional patent application. That definitely could be suitable for that.
Okay, let's see. We have a few more. Let's see what we can get to in the next 5.5 minutes. So if you want to look at successful patents, can I peruse them, and where would I go to do this? I'd like to read a few well-written ones.
Yeah, so we also recommended that it really depends on the field of technology. And to see, let's say, for instance, you're interested in finding I don't know, just in my area of examination, let's say just whether if I have a speech processing application that is now being able to recognize a multilingual, first and second language recognizer. So I should be interested in seeing whether these additional elements are there in the literature, in the patent and non-patent literature. So the best way is to think about the terms of art that I use in that certain scenario, and become yourself familiarized with terms of art, is what we call them. For this particular hypothetical example, ASR, automatic speech recognition, um, text dependent. So and that's the idea, is that you become familiarized with the jargon of your area, of your technology field, because that'll offer a lot of value when you describe your invention. The examiner is an expert in that area. So the examiner will immediately be able as a fact finder, will immediately say, so perhaps this is related to text independent speech recognition system. This could be a multilingual system. This could also be applicable to these other areas. So the best recommendation is just become yourself familiarized with the technology that you're working on and those terms of art.
Let's see, if your invention has 3 different ways to be applied, do you show the different applications, or can you just list the different ways they are applied?
Could you elaborate on that question?
Okay, so James asked that question. James, if you can elaborate, I'll read the question again, but if your invention has 3 different ways to be applied, do you show the different applications, or can you just list the different ways they are applied? And if James can elaborate, we'll go back to that one.
I think I got
You got it now? Okay, James, no
that.
need to type anything in. He's got it. We're
Okay.
good.
So I think this is more in the direction of embodiments of your invention. Okay. So when you offer the description of your invention, eh, the best way how to make and use essentially is what we call, right? So disclosure, essentially 112 or 35 USC 112 will allow you to say, okay, this is how it works. This is how I can make, this is how I can use. And if your make and use is directed to one particular way of doing things in your invention, then we can perhaps call that one embodiment. Now, if you're interested in describing difference between that, I think the most suitable way would be to see if you can get yourself into explaining additional ways of how that works instead of just listing this is the difference. Because if you just list the difference, then you may not necessarily saying, oh, this is a second embodiment or this is a third embodiment, but rather modes of operation.
All right. We have a few more. We have a few more questions. Let's see what we can get in. Let's see. Is there a public disclosure requirement related to design patents?
Public disclosure requirement. Well, I'm going to be honest with you. I'm not strictly familiarized with design patents, but I can tell you that in the utility patents, after 18 months that you file a non-provisional, it becomes it gets published essentially, unless you filed for a non-publication certificate.
Here's one. Can one get a patent for foods?
For foods, okay. So if you, let's say, for instance, you have another hypothetical example, you're interested in protecting the secret recipe of grandma, let's say, right? And so you have your interested in protecting the elaboration of this cookie, this super cookie, super delicious, that you like to get it protected. Of course, in order to get that product, you have to have most likely a process of baking, a process of manufacturing that cookie. So in that case, definitely that's an example that could definitely be captured as a process, as a potential or most likely an example of a utility patent. So that's just one way how you could see it. There could be different other a different strategy that your legal counsel might suggest, because there are many other intellectual property rights, copyrights in this case. You're interested in protecting the recipe. Could be a trade secret. There could be you like to create all these book of recipes of how to create these fantastic, these delicious cookies. So you might be interested in protecting the recipe as a whole in different modifications of it.
Okay, Edgar, thank you. We have a few more questions, but we are out of time. So I'm going to ask everyone, if your question didn't get answered, please send an email to help@virginiasbdc.org, and we'll make sure to get your questions answered. And Edgar, thank you so much. Again, wonderful information. I want to thank everyone who attended the webinar today. As a reminder, you're going to receive an email with a link to the recording and to the slides. If you would like to sign up for upcoming webinars or access recorded webinars, please visit virginiasbdc.org/training. These resources are designed to be used in collaboration with your local SBDC advisors. You can sign up for a free and confidential session by emailing help@virginiasbdc.org or via our website. And we hope to see you all at our next session. Thanks again, Edgar, and thank everyone for being here. Take care.
Absolutely. My pleasure. Thank you so much. See you guys next time. Thank you.